Hi there. Happy New Year. I'm Savannah Mexter with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. Speaking of the new year, what if there was a resolution that could relieve stress, offer peace of mind, help you and your family, and practically keep itself? Well, guess what? There is. On this special New Year edition of Webinar Wednesday, Bob will be sharing why an estate plan could be the perfect New Year's resolution and why we say it's a resolution that lasts. Before I pass the mic, I'd like to cover a few housekeeping details. First, even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. If you have a general question during today's presentation, I encourage you to use the question box. We will save time at the end of the presentation to review questions. If for some reason we don't get to your question, we will contact you after the webinar. Lastly, today's presentation will be recorded and the replay will be sent out tomorrow so that you can share this with family, friends, or anyone who you think could benefit from hearing the information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're nationally recognized and respected elder law and estate planning firm. Also, all three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan, Elder Law and Disability Rights Section, and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. It is a good idea to start off the year making sure you have your ducks in a row, right? So a lot of people seem to have this resolution. It's one of those things that people tend to put off a little bit. And just like other things that we sometimes focus on January 1st or at the beginning of the year, seems like it's a turnover, a fresh start, and we just want to get some of those things taken care of. So today's just going to be a back to basics presentation about what everybody really needs. And so there's four basic documents that most people need. And we're going to go through those and why they're important and why it's important that they're done well and designed for your specific needs, as opposed to just kind of some form-based or generic planning. So there often is, when we think about getting our ducks in a row, getting our affairs in order, there's really two approaches. There's the will-based planning, and then there's the trust-based planning. And then there's other people that just kind of have a hodgepodge of things where they put beneficiary designations on some things, and they have a deed that they have stored away somewhere that's not supposed to be filed until a later date. All those types of things are more of a hodgepodge and not really a plan. So we really can't call that a plan if we don't have a overall plan that says, well, here's what's going to happen to everything. Here's how I want things to be to go if I get sick or after I die. And so ultimately, for those that are interested in making sure that they have things in order rather than just kind of everything hodgepodge, is two options. There's either a will-based plan or a trust-based plan, and we're going to kind of go through the distinctions there. So what are the goals here? What's the goals of planning? And primarily the goals of planning, there's four basic goals of planning. Probate avoidance. Many people say, well, why do we have to go through probate? Why do we have to have this court process when I've got perfectly competent family members that can, take care of things for me in the event I'm sick, or make the arrangements in the event that, or after I pass away, and distribute the assets appropriately? So there are plenty of ways to avoid probate, and ideally we have a plan that makes sure that everything is covered, that we're not leaving anything to chance here. And so probate avoidance is one of those important goals. The next thing is asset protection. Now, asset protection can a number of things. People mean different things by asset protection. Sometimes people think of asset protection and they mean, well, basically protection from the government. In other words, keeping it out of government control. That's certainly an element of asset protection. Other people mean that they want protections from lawsuits and things like that. But the big one that a lot of people are concerned about is asset protection in the event that we get sick. So God forbid, if you ever had to go to a nursing home or you needed 24-hour care in your home, that can get extremely expensive, and even people that have done very well and have lots of money could go through that money very quickly if we have an extended period of time where we need 24-hour care. So are there ways to protect your assets from that? And absolutely there are, and that's a big part of what we do as part of our planning. The next thing is inheritance protection. So inheritance protection is something that a lot of people don't think about and a lot of lawyers don't actually plan for. So a lot of people, when they go to their lawyer to get their will or trust done, they really stop the conversation after the point of death. It's okay, I died, now everything gets distributed out, everybody gets their sack full of cash and walk home with their, and that's not the way it really works. And the idea is there's things that we can do to set things up for your family, your loved ones, after you're gone, not to control them, but to give them some advantages, to give them some benefits of your planning. And so the inheritance protection is something that you can do to protect your kids or your beneficiaries in case they were to get divorced. You want to make sure that the money doesn't get caught up in the divorce, or even if they had financial troubles. Okay, is there a way that you could leave money to your kids and it's just not going to get eaten up by their creditors if they have, if they have some financial problems, or lawsuits? What if they got into a lawsuit or a car accident, or what if they had a sickness? Is there a way that we could make sure that the kids can get their inheritance and it's not going to be eaten up by medical costs, that they'll be able to qualify for different government programs that would cover medical costs? And the answer is absolutely. That's a big part of what we do also, is to say, okay, we don't want to control the kids after our death. We just want to give them some advantages that they, if you work so hard to save this money and have something to leave behind for your family, and maybe we should think about giving them the opportunity to protect that after you're gone, so that if they run into trouble, the money that you leave them doesn't just get eaten up because of their troubles, whether it be health related or lawsuits or financial related or divorce. So, and then finally, tax avoidance. This is something we've been talking about a lot lately. There is certainly what people often sometimes talk about is the death tax, the estate tax. For most of us, the estate tax doesn't really matter anymore if you're a Michigan resident. Now, if you live somewhere else, there's still estate taxes in many states, but not in Michigan. There's no estate tax for the state of Michigan. There is still an estate tax on the federal level, but you have to be up in the $12 million range before you have to worry about that. So if you have less than $12 million to give away, then we really don't have to worry about estate taxes. But that doesn't mean that we don't have to worry about taxes, okay? So it's very important that we plan for capital gains, because if you buy stock and it increases, if you have a second home and the value of that home has increased, then when you sell it, that can be considered a gain. And there's ways that we can avoid that capital gains when we leave things to the kids. And we have to do it in the right way to make sure they get that what's called step up in basis, meaning that they will be able to avoid those capital gains taxes. And then the big one, of course, is going to be related to any retirement accounts that you have. So we're going to touch briefly on that today about retirement accounts, because it's a big deal now, specifically as it relates to your estate planning. So this might not be something that you've thought about before. You just have a 401k, you have an IRA, and you say, all right, no problem. We're going to go ahead and just leave our kids as the beneficiary on our IRA. We're going to leave the kids as our beneficiary on the 401k. And under the new tax law called the Secure Act, there are some advantages, significant advantages, of actually incorporating that into your trust, incorporating that into your estate plan, something that you might not have considered prior to this change in the law. And that law change just occurred 1 year ago, January 1st, 2020. So important things to consider when we're looking at getting our affairs in order and getting our planning done. It's one of those things, a lot of people will have a New Year's resolution to lose weight or start working out or things like that. Well, this is one of the things that you can actually get done and accomplish. And it's one of those things that you don't really just want to leave to form documents. You're not going to want to leave it to an attorney or have it drafted by an attorney that doesn't really focus on this area of the law and really understand the nuances of the taxes and inheritance and asset protection and probate avoidance, and really is more of a complete holistic process. It's not something that you want to just leave to chance. Okay, so let's just spend a couple of minutes talking about those things. Well, one of the things I think it's important to think about when it comes to legal planning, there's really a distinction between what happens during your lifetime and what happens after death. And so many people tend to think about, oh, well, I need to go to my lawyer to get my will drafted because I want to make sure what's going to happen after I die. But just as important, and I would suggest more important, is what happens before you die, or what happens if you don't die, what happens if you get sick, what happens if you live to be 100. What's going to happen between now and the time that you die? That's just as important, if not more important, and I would argue it's more important. But it's really something to think about from a standpoint of the legal documents, because we use different legal documents and different legal processes in lifetime than we do after death. And you see, there's actually only one legal process or legal document that overlaps both, and that's trust. These are, sometimes referred to as revocable living trusts. So the trusts are the only thing that we can really have a comprehensive plan. It's one of the reasons why I often recommend trust, is it's a comprehensive plan both for lifetime, for illness, and for after death. Whereas all these others, we're going to have one legal process or one set of legal documents for lifetime, and a second legal process or a second set of documents for after death. So we have the durable power of attorney. These are the four basic things that we need to be looking at. The financial durable power of attorney, the healthcare directive, a will. Even if you have a trust, we still have a will as a backup. And of course, for most people, we're going to be looking at whether or not it's appropriate to do a trust. If we don't have a durable power of attorney and we get sick, we may need to set up a conservatorship through the court, where the court appoints somebody to be in charge of your money. If we don't have a healthcare power of attorney, we might have to go to court and get a guardianship, where the court appoints somebody to make your medical decisions for you and your living decisions for you, okay? So then after death, all of those go away when you die. The durable power of attorney has no effect after you die. Sometimes people try to use it, they shouldn't. It's actually not a legally binding document anymore. Once you pass away, the durable power of attorney is no longer effective. The healthcare advocate is no longer effective. Guardianship is no longer effective. Your guardianship, if you were appointed guardian of somebody, that ends on the death of that person. You still have some reporting to do because it's court. Of course, you're going to have to do some paperwork. You still have to report. You have to do a final inventory and a final report and all those types of things for guardianship and conservatorship. But the legal authority to act ends upon death. And then after death, we have the possibility of going through a decedent's estate or going through probate. If we have a will and we need the will to determine where things are going to go, then we have to go through that probate process, okay? We also have the possibility of beneficiary designations or payable on death. And then, like I said, in the middle, we have something that covers all of that, the more sort of holistic plan that covers things during your lifetime, after you get sick, and after you die, so we don't have to go through probate. We don't have to involve the court in a guardianship or conservatorship. All right. So one of the things that a lot of folks do, and no matter how many times I say this, I know people are still going to do it, but I really caution against that, and that's adding your kids' names. So a lot of folks, they say, in fact, the bank will even tell you to do this. So many times we've sent folks to their bank when we had the trust set up, and we say, okay, give the bank this information about the trust so we can have the accounts at the bank in the trust. And they go to the bank and the teller or somebody says, well, why don't you just put the kids' names on it? Or, we have clients that have a whole estate plan that's all organized and all set up, and they'll go and, their friends or their banker or, sometimes even their professional, their accountant or somebody says, oh, well, you better put your kids' names on it. You're getting older. No, that's a really bad idea, because when you think about it, when you put your kids' names on it, that means the kids own it. And it's not, sometimes people think I'm saying that we don't trust the kids. Well, I hope you trust your kids, but I suspect you probably wouldn't put their names on it if you didn't trust them. But it's not about the trust issue. It's about liability. So anything that bad happens to your kids now affects you. So if they get divorced, your money could be exposed to that divorce. If they get in a lawsuit, your money could be exposed to that lawsuit. If they get in a car accident, if they go to the nursing home, if they get sick, if they have medical expenses, if they have lose their house to a foreclosure, anything bad happens to them affects your money. So it's just a really bad idea to put kids' names on it, and there's much better ways. That's why we have a financial power of attorney. That's why we have a trust. So both of those would solve that problem without having the liability of having the kids own the accounts. We don't want them to own the accounts. We don't want their names on the account. They can act on your behalf through a power of attorney, through a trust. We don't want them on the account because that means anything bad happening to them is now also happening to you. All right. So if you've planned, just a real refresher here, if you've planned, you're going to have a durable power of attorney for health care. That's somebody to make healthcare decisions for you in the event that you can't. If you haven't planned, then we might have to get a court-appointed guardian. So the court decides who's going to make medical decisions, who's going to decide where you live if you become incapacitated, if you get too sick, all those types of things. So you can determine that, or you can have a court determine that. If you planned, you have a durable power of attorney for finances and legal decisions. If you don't and you get sick and somebody needs to make financial decisions for you, we could have to go get a court-appointed conservator, where the court's going to decide who's going to make financial decisions for you and how to, whether to sell your house or things like that. This is one of the comments I hear all the time. Oh, I don't have to worry about that because I've got beneficiaries on my accounts. I put payable on death on my account. I put transfer on death on my account. Or I don't have to worry about that because I have my kids' names on my accounts. Well, we just talked about why that's a bad idea. In fact, I call it the 4 Ds. The 4 Ds is you put your money at risk to the 4 Ds. Divorce. Your kids get divorced, their name's on it, the money is exposed to the divorce. Debt. Your child doesn't always tell you if they're having financial troubles, right? Maybe they do, maybe they don't. But if they have financial troubles, now you have financial troubles because their debt, your money is exposed to their debt if you put their name on it. Disability. This is a big one. We kind of assume that parents are going to get sick before kids, but we know that's not always true, right? The kids could get sick. But even more so, what if your daughter's husband got sick? Well, in Michigan, spouses are responsible for each other's medical expenses, at least during lifetime. And so if your daughter's on your account and her husband gets sick, then your money could be exposed to your daughter's husband's medical expenses. And what I mean by that is they couldn't qualify for other programs. They couldn't qualify for Medicaid or disability or those types of things because you put your daughter's name on the account, and because her husband's sick now, your money is causing them not to be able to get medical expenses paid for under the different programs or insurances that are available. All right, and then finally, death. What if people die in the wrong order, right? And so if we have a daughter name on it and she passes away, then that can be problematic. So if you have planned, you have a will or a trust. And we talked about typically when we have a plan, we're going to either do a will-based plan, meaning we are going to end up going through court at some point, or a trust-based plan. If you haven't planned, if you don't do anything, then the state of Michigan has written a will for you, and they call it intestate. Intestate succession is the word that they use. And there's this whole set of laws that say what happens to your stuff and who's in charge if you haven't designated that. All right, we're going to spend a couple minutes on what happens to the money after you die. So we talked about the importance of having planning for your lifetime. If you get sick, if you get old enough and you need somebody to help you with things, then it's important to have those lifetime documents. So let's spend a few minutes about what happens after your death. So I always laugh when I see these movies that show everybody going to the lawyer's office after mom or dad dies, and the lawyer's like handing out car keys and handing out checks. That's just not the way it happens. There's no reading of the will. That's not a realistic thing. That's not what people do. That's just a movie invention. And so, but there's the sort of expectation sometimes that after somebody dies, that they're going to go to the lawyers and then they're going to walk home from the lawyers with a sack full of cash. Like that's with the inheritance. And so what happens if the kids walk home with a sack full of cash? Well, so I have this um, example family, and there's the three kids, Susie, Roger, and Danny, and we love them all, and we want them all to get an equal share. We really hope that the money we leave for Susie doesn't get in the hands of her husband, our idiot son-in-law. And so what if they get divorced? You know, so Susie gets an inheritance, and the next year they get divorced, or even if they don't get divorced, and he just, you know, he gets his hands on it and makes bad decisions, or he's just bad with money and things like that. Is there a way that we could get the inheritance to Susie and make sure that her husband can't get his hands on it? And if they get divorced, it's not going to be divided up in the divorce. And then we've got Roger. Now, Roger, the concern that we have is, although he's done, you know, fairly well from time to time, he's had businesses that failed, or he has some other reason why he has some financial troubles. So wouldn't it be great if we could leave the money to Roger, but we'd hate to see it all go away immediately on you know, he gets the inheritance, he gets that sack full of cash, and then all of his creditors come and garnish the money or take the money right away. Wouldn't it be great if we could leave the money to Roger and not have it eaten up by his old debt, right? Is there a way to do that? And the answer is absolutely there is. And then finally, we have Danny. Now, Danny's a different situation. Danny is on Social Security disability. So Danny had some issue from birth that he was never able to really work, and so he was able to qualify for medical benefits and disability benefits. If you leave him money directly, guess what? He'll lose those medical benefits. He'll lose those disability benefits. So how can we get the money to Danny and make sure that he's still going to be able to get his medical benefits? Okay. And then finally, Uncle Sam, our fourth child. We think of that sometimes, right? The government kind of seems like our fourth child because they always have their hand out and say, you know, I want some money. And so is there a way we can minimize what we leave to Uncle Sam as far as taxes? And the answer is, of course, there is. So this is the first thing. We're going to talk about taxes in a second here, but the first thing is if we leave the money to them in the form of a lifetime protector trust. So these don't come into existence until you die, but once you die, then each Susie gets her trust, Roger gets his trust, and Danny gets his trust. With Susie and Roger, they can control their own shares. Susie can control her share, Roger can control his share. With Danny, we can't allow him to control his share because then he'd lose his medical benefits, he'd lose his disability benefits. But we could put Susie or Roger in charge of his share, or somebody else, or even a banker, an accountant, or somebody like that, and make sure he's going to get the value, he's going to get the inheritance, he just doesn't get it directly, so he can keep his medical benefits and other benefits. So this is a really nice thing, and something that a lot of lawyers overlook, and it's really not all that complicated. It's just lawyers often will overlook this. They don't plan for after death. They say, okay, death, here's the money, we're going to divide everything up. And the idea is, why not? Why not set it up where we can give a gift to Susie, Roger, and Danny? And that's the gift of making sure they get the inheritance in a way that they're going to be able to preserve it, and maybe even save them on taxes, which is what we're going to talk about next. So, of course, we want to minimize any estate taxes, and there's multiple strategies for that. When we talk about capital gains taxes, this is where you're going to really want a qualified attorney, a experienced attorney, because we got to look at every single asset you have and think about what is the tax consequences of that, leaving that to the kids, and is there going to be capital gains? Is there a way to minimize capital gains? Can we make sure we keep our step up in basis? And so this is something that's often overlooked by accountants and financial advisors and lawyers, and it's something that we really have to include as part of our discussion, as part of our thought process when we're putting those things together. But then the final thing that a lot of times people overlook is with regard to retirement assets. So your IRA, your 401k, your Roth, qualified annuities, PSP, anything that was a retirement asset that has special tax advantages to it. So they just changed the law on this. And so they basically said, okay, after you die, we're going to change how it gets taxed, and it's going to be in one of these three columns, all right? And so this is very important that we make sure that we're in the right column, and that's where the trust can come in. That's where your legal planning can come in to make sure that we're in the right column, because here's the big key on this. This is what people forget about. This is the big piece of advice. You really can't figure out what column you're going to be in until you die. We don't know when you're going to die. We don't know when you're going to, who your beneficiaries are. We don't know who's going to be living when you die. We don't know what their ages are going to be. We don't know what their circumstances. We don't know if they're sick. What if they're, they've had some financial or medical troubles or anything like that. All of that's not determined until you die, because we don't know when you're going to die, and we don't know what assets you're going to have at that time. So we have to set up your estate planning to make sure that we get into the proper column here, so that we don't end up giving too much money to Uncle Sam. Because if we end up in the red column, which is what we want to absolutely avoid, as a non-designated beneficiary, then we have to pay all the taxes in 5 years. And if you have a trust and it goes to the trust and the trust doesn't have the proper language in it, you can see here that certain trusts will be considered a non-designated beneficiary. So you designated your trust as the beneficiary, but the IRS says some trusts are going to be considered a non-designated beneficiary, meaning we have to pay the taxes faster, meaning that we have to pay more taxes, a greater percentage of taxes typically. So we want to at least be in this yellow column, a designated beneficiary. And you can see if we set up the trust properly, then we can be in that designated beneficiary column, and they will have 10 years to pay the taxes on it. But even better, what if we could get into this green column? And the thing is, we don't know if we can get into this green column until you die. So we better incorporate this language in your legal documents. And if we haven't, then we need to update it. And so we just contacted, in the last year, we contacted all of our clients that we could find and told them, hey, you might want to think about updating your legal documents, because we want to make sure we have this language in there for the eligible designated beneficiary, this green column, so that if any of these things apply when you die, then we can save taxes. We can have a longer time to pay the taxes, pay less taxes, pay a smaller percentage of taxes, and continue the benefits, like with the Roth, continue the Roth benefits of letting things grow tax-free. And how do I know that, we don't know if you can be in the green column? So you might look at these and say, well, I don't have any of those people. Well, we don't know that you don't have any of those people. We don't know that the people that you leave things to might not be considered chronically ill at the time of your death. It could be 20 years from now, 30 years from now, 50 years from now. We don't know when you're going to die. We don't know what's going to happen next year. With 2020, we could see very much that you can't predict things. That was a crazy year. And so we don't know what the circumstance is going to be. And so we have to add this into the language of your trust, so that if in fact your beneficiary, your child, whoever it is considered chronically ill, which spouse dies first? If you're married, we don't know which spouse is going to die first. We got to make sure that we've got that included. Minor beneficiaries. Your child may want to defer and say, well, I'd rather leave this IRA on, mom's IRA, mom dies. I'd rather leave it to my child so that it goes on to the grandchild. You don't need to make that determination. You can allow your child to make that determination, and we can make that determination at the time of your death. So it might be 20 years from now. At 20 years from now, we might not want the grandchild to inherit it, or maybe we will. It would be up to your child to be able to make that determination, but we have to have all that language in there. So this is really important now, especially since January 1st of 2020, when the Secure Act took effect. So what questions do you have? I'm going to look here if I see any questions. And Savannah's going to come on in a minute. For those, if you have a question, you can type it in now. If you have a question that you want to submit to us, Savannah's going to give you some instructions, not only how to submit a question and get a phone call with us, but also it might be time to, this would be a good New Year's resolution. It might be time to come in and do a review and make sure that you've got all these things covered with qualified attorneys here. So Savannah's going to step in, and we will she'll give you some instructions as to what to do next.
Thanks, Bob. So as Bob mentioned, we do have a way for you to send your questions to us or contact us. If you'd like to learn more about getting your own planning or just have general questions, we're here. So there are two ways to contact us. You can always call. Our phone number is 810-694-9000, and I'm actually typing that into the chat, so 810-694-9000. And there's also an easy way to get in touch with us. If you can't make a call right now, or you're just busy, or you just know, I want to think about this first, also in the chat, I've put a link When you click that link, it takes you to a calendar. You'll choose a day and a time when a member of our team can give you a call. So you'll have a choice to choose a time that's convenient for you. The call will take about 15 minutes. There's no cost to the call, no risk or obligation. It's just a way for you to ask us questions and for us to get to know you a little bit too. So again, our phone number is 810-694-9000, and I have gone ahead and put that link in the chat. I will tomorrow send out a replay of today's presentation to your email. There'll be that link and the phone number in the email as well. And I do encourage you to share the email and the replay with your family, friends, or anyone who you think could benefit from hearing this information. Thanks so much for joining us today. Happy New Year, and we'll see you next week.